The broadcast is now starting. All attendees are in listen-only mode.
Hello everybody in Athens. This is Linda Plano. Welcome to Plano and Simple Ask a Pro, featuring my friend and colleague Jerry O'Connor, who is a partner at Saul Ewing and one of my favorite attorneys for entrepreneurs as well as others. Jerry, we're going to introduce you in more detail in a few minutes, but if you want to just say hello to the audience, then please go ahead.
Hi everybody. Pleased to be here and look forward to the webinar.
Excellent. Okay. So first of all, before we go any further, I do want to make sure and say thank you to Vasilis and Katerina, who have been instrumental in putting this whole program together, including the webinars. And also want to make sure everybody is familiar with how to participate today, if you want to talk especially. But first thing, just take a look in the upper right corner of your screen. There's a red and white arrow that will let you get at your toolbox. If you want to talk or try out a pitch on me later on, we probably won't have time for any pitch practice today. That's tomorrow. But if you want to ask Jerry a question, then you need to be sure that you've got your audio mode selected that works best for you. If you want to use a telephone, select the radio button and then audio setup. Make sure that you put in your audio PIN when you're prompted for it. If you just want to send in text questions, I will be keeping an eye on them throughout the presentation, so just type them in that box. And just so I can be sure that my audio problems are fixed, if you can hear me, would you please raise your hand? Okay, great. Thank you. Okay, that's great. Thanks, everybody. Okay, so we're going to quickly cover the Perfect Pitch Workshop coming up, and to remind you that even though I am leaving at almost 11 o'clock tomorrow night, we're still doing another webinar tomorrow. This is going to be about the best preparations you can do for the workshop coming up next week. I hope you can join me for that. And then we'll get into the meat of this webinar, which is what you're all really here for, to talk to Jerry. This is just a quick overview of the schedule. As you can see, we've got one event that is just for investors on how to pick a startup. You'll also have an opportunity, if you participate in the Perfect Pitch Workshop on Thursday and Friday next week, you'll have the opportunity, if you want it, to do a 1-minute pitch to the investors here and get some feedback. We'll make sure you're not talking about proprietary information or anything like that. It's just supposed to be a learning experience and an opportunity to get to network with some investors. On Thursday night, we've got a team building event. You'll get a chance to try out your 1-minute pitch there and also try to attract some great new team members to your startup. And on Tuesday, the last night of Build the Community, is the Investor Pitch Showcase. So the top 10 of you guys who do the workshop will have the opportunity to do your 10-minute investor pitch in front of everybody in the community who comes to attend this exciting event, which I think is going to be a really fun event. And also I'll make myself available for office hours all day on Tuesday, Monday night once the investors are done with me, and even on Saturday if you want to work on Saturday. Okay, let's see. There is a link that you can use to apply to get your 10-minute pitch coached during the workshop and to be considered for this. Let me just show that real quick. Sorry, I should have had this set up ahead of time. Just bear with me for a second while that's coming up. I'll just go to the next page. And what I really want to emphasize here is the idea for your participating throughout the Build a Community program is to actually get to implement what you learn in the workshop, to get one-on-one coaching from me on any aspect of your business you want, but obviously especially on your pitch, the opportunity to grow your startup through the team building event and to raise your profile and do some great networking at the team building showcase. If you want to apply to have your 10-minute pitch coached, here it is. It is at PPW for Perfect Pitch Workshop -bonus-coaching. And I am going to ask you to do a little bit of work. Not too much. I just need to see your elevator pitch and why you think you should be chosen. Okay. Oops, yes, raise your profile, exactly. Okay, and finally, the last webinars we have coming up are the one right now, and then tomorrow at, I believe it's 16 o'clock your time. Is this going to be your last chance to ask any questions about the workshop, unless, of course, you are willing to come and buy me a drink at the Fresh Hotel this Saturday evening through Monday. It would be great to meet any of you ahead of time, but I'll be no worries if not. I'll actually do any question answering via email or anything else that you want. But if you have a chance, drop by, let me know you're coming, and let's have a drink. Okay. Finally, I just want to say thank you to all of the annual sponsors for the MIT Enterprise Forum of Greece, without whom none of this would be possible. Okay, now to what you really came here for, which is to meet my friend Jerry. Jerry is incredibly experienced. He's actually been working with me on lots of different programs in clean energy and life sciences and so on for the last almost 10 years now. Good heavens. Good thing we were teenagers when we started out, huh, Jerry?
Exactly.
Jerry has experience in M&A, corporate finance, securities law, intellectual property. He's general counsel. I have used him as a corporate attorney in my own companies in the past. He is one of the best negotiators I know. He never ever loses his cool, and he always thinks strategically, which I have to tell you is not something that is typical for all attorneys. Many are good at it, but definitely not all. And let's see, I was actually going to drop some of these out here just so I could get through them. But suffice to say, Jerry has done work with Canadians, with Chinese, with European companies, with government organizations, and life sciences, in clean tech, and in digital technology. There's really no area you can touch on that he won't have at least something useful to say. So, with all of that, Jerry, I will say welcome to Ask a Pro, and how are you today?
Great. Glad to be here, and let's just jump right in, I guess.
Okay, great. Let's see, actually, I do see one hand that is still up, so let me just pull out the questions and make sure there isn't a pending question. No, it looks like we're okay. Great. So today we're going to touch on two major topics. First, best practices for entrepreneurs, and second, doing business in the U.S. For European startups. So I think one of the hardest things for a first-time entrepreneur is to really find a kind of support and help that is useful, is smart, and is cost-effective. We do have a fair amount of background noise here, Jerry. So if you've got something close to your mic, if you can put it to the side, that'd be awesome. Anyway, so how would you recommend that people who are interested in building a startup company go about finding an attorney who's appropriate for them?
Ask somebody who's been through it, and not just somebody who's just started a company and said, "Oh, I've got a great deal," and somebody just, some attorney in Boston, New York, deferred a bunch of fees. Find somebody who's been through the life cycle of a company, because having a startup is great, but then you're also going to go through the growth phase. You're going to encounter various financing sources. And hopefully, if you're successful, you're going to have an exit of some sort. And having somebody on board from day one who can take you through the entire life cycle is really what you're looking for. So find somebody who's been through all the ups and downs and through the life cycle with a good set of counselors and get recommendations. That's how, for me, on the other side of the equation, that's how most of my new client work comes in. And that's how I advise people to find other advisors. And the same thing goes for a tax advisor or an accounting advisor, or even if you're putting together your advisory board in the early days of your company.
Yeah, one of my favorite sayings from Sharon Ballard, who's also an entrepreneur coach, is that, all attorneys cost the same in the end. You either pay upfront for a good one or you pay over the long run to fix the mistakes of a mediocre attorney.
Yeah.
That said, though, one of the challenges for a new entrepreneur who's really new to entrepreneurship is they really don't know anybody in the community. So do you have any advice on networking in and getting that kind of advice?
Yeah, I mean, networking is an essential piece of building a startup. Here in the Boston area, we have some great networking opportunities, primarily through the MIT Enterprise Forum of Cambridge. And I think finding where the nucleus is of the entrepreneurial community in your own community, and I know there are things like GreekStartups.com, and I assume there are other things like the MIT Enterprise Forum of Cambridge. And I think that again, finding people who have been through the entire life cycle and can reflect on it in a way that's helpful to you is a way to network. You're gonna need not just an attorney, but you're gonna need business advisors. You're gonna have to recruit people for your team if you're starting with one or two founders and an idea. You're gonna have to have a vision of where you're gonna go and what kind of people you're gonna need to build your team. So networking is critical, not just for your professional advisors, but for building your team as well. And I'm obviously stating the obvious. Anybody on the phone that's increased their team from one to any more than one knows how difficult a challenge that is.
Well, absolutely, and that's why we put in the team building event in the Build a Community series. I mean, I'm a sole practitioner myself, and I look for opportunities to have people to support me in different aspects every chance that I get, and that's even after networking for 10 years. So it's an ongoing process. In
terms of industries or technology spaces represented in this group, Linda, do we have mostly software or web-enabled technology? Do we have any life science or clean tech entrepreneurs in this group?
I don't actually know, so let me just ask in a row here. So first of all, do we have any digital technology entrepreneurs online? Please raise your hand. Okay, got a couple of several of those. That's probably going to be the dominant. Okay, anybody in life sciences? Okay, and that's a smaller turnout, but there's still some. And anybody in clean tech? Okay, last question. Anybody in, let's say, retail?
Or manufacturing.
Or manufacturing, right. Okay, it doesn't look like we have anybody in either of the last two.
Okay, it's always good to know, kind of what the makeup is of the group in terms of what space they're in, even though some of the advice to entrepreneurs goes across the board, and other pieces are more or less important depending on what space you're in.
Right. Oh, okay, great. Oops, got another hand up. I keep getting distracted by the little hand symbols up there. Let's see. Okay, so now, of course, every time you talk to an entrepreneur, there is every time an entrepreneur is looking for support, price is obviously an issue, and we were just talking about that a little bit. And you're right, it's important not to be penny wise and pound foolish, but how do you suggest starting? How can they do the best job of selecting an attorney by getting information ahead of time, other than the referrals? Can you do a 1-hour consult? Is that reasonable? Or any tips for that?
Yes, that is reasonable. Almost any decent corporate attorney will do an initial consultation to help you figure out what issues and challenges you have and how they can help you. I will always do an initial consultation with any potential client, for the most part, unless they're obviously a lunatic of some sort.
I don't know. I've sent you some lunatics.
That's not necessarily disqualification.
Okay.
But it's part of me getting to know a client, and it's part of a client getting to know their potential professional service provider. And there should be no hesitation whatever in if somebody has been referred to you, to reach out by email or phone and set up a time for an initial consultation where you can explain what your startup is doing, what you think your challenges are, and then ask, what do you think my challenges are. How would you help me? That's a perfectly good question to ask, whether you're talking to an accountant or a lawyer or someone who you're thinking about for your advisory board, but especially for a lawyer. How would you help me? What do you think I need to do for my company based on your experience?
Excellent.
And you might get advice back that you hadn't thought of, or you might get you might find that you were right on track and you're thinking along the same lines. And I'm not sure which response is better, but that's how you should approach it. And have a few of those conversations, and you have to get as many good recommendations from experienced entrepreneurs as you can. Go online and figure out who's who and who seems to be a fit on that basis, and then have 3 or 4 at least of those consultations, and all the attorneys will know that those are preliminary discussions, and then make a decision.
Great. And actually, the chairman of the MIT Enterprise Forum of Greece has his hand up, so it's gone up several times, so I think maybe he's got a comment. Vasilis?
No.
No, you're just overly eager on the hand button. Well, if either of you either you or Katerina has a comment about doing things in Greece, commenting according to what Jerry is talking about, please by all means put your hand back up, and we'll try to adjust that. We'll bring you in. Okay, so next, is it important to have a specialist? Do you need a different attorney for intellectual property versus corporate versus anything else?
The answer is yes, but. If you want to file a patent, pretty much anywhere, you need somebody who's a registered patent attorney. Certainly in the United States, you need somebody who's a registered patent attorney, licensed to practice before the United States Patent and Trademark Office. Period. I can't file your patent for you. I can submit a trademark application for you, and I do. I will not file your patent application for you. So yes, as a technical matter, you absolutely need a patent attorney to file a patent application. However, if your startup is intellectual property dependent, or you expect it to be, and just about every company I work with, and I assume that everybody on this call is dependent on intellectual property to a great degree for the success of their venture, then you need all of your advisors, your accountants. If you're a software company, you've got to have an accountant that knows how to do the right revenue recognition, whether you're under international financial reporting or GAAP. You need an attorney who knows the risks of that business and the intellectual property risks and challenges. And you need a corporate attorney who understands intellectual property and how the intellectual property strategy is going to inform your entity selection, where you're choosing to do business, what kind of sister relationship are you going to have if you're going to have a European entity plus a U.S. entity. Intellectual property plays a huge role in that, and you need somebody who's conversant in that, in my opinion.
Well, that's what we're here for.
If you don't, then you better get your IP attorney and your corporate attorney on the phone regularly, even though it might make your eyes cross and make your blood pressure go up to imagine two hourly billers just spending the time chit-chatting with each other. I think that it's imperative to make sure everybody has the same roadmap. So it's simply a challenge of running the startup. Your IP folks have to be talking to the corporate folks and the tax folks.
Yeah, I have to say that is always a challenge, since I know so many people in the community at this point that it's hard to keep straight. I want to come in and just talk to somebody who I've actually hired, and I'm just chit-chatting. I feel like I'm chit-chatting, but I'm actually getting billed for it. And, it's completely appropriate in retrospect, but if I'm not thinking about it at the time, it can add up quickly.
Yeah, but you know what else? It's not really appropriate. The communication in the startup world, that kind of a mistake is because it's like anything else. If you're one degree off at the start of launching your rocket ship, then you're never going to get anywhere near the destination. And seemingly small mistakes have big impacts, and seemingly small or errant bills have big impacts on a startup. And so you've got to be communicating with your professional advisors so they understand what they should be billing you for and what they shouldn't be billing you for. And that's got to be completely transparent. You should never get a bill from your lawyer that you don't understand. Still, it happens. And if you do, you should be able to pick up the phone and say, what's going on here?
Yeah. In fact, I encourage entrepreneurs always to write everything down, whether it's with their co-founders or even with any of their service providers, because otherwise you're just saying the same words can mean different things to different people.
Let me make a point about a trend in the U.S., and I don't know how much of a trend it is in Athens or Greece, and that is especially for legal services, not so much for accountants. There are a couple of flavors of providing legal services to startups, mostly proffered by the larger firms in New York, California, and Boston. One of them is to defer fees. We're going to bring you on as a client. We're going to do legal services for you, and we're going to defer $20,000, $25,000, even more of your legal fees until you get your Series A funding from a venture capital firm, and then we're going to collect. Well, what I've seen many, many times is that when you have that kind of relationship in place, nobody's paying enough attention to those little, build conversations, and nobody's paying enough attention to, the couple of associates at the law firm that might be going around doing the incorporation work and the founders agreements. And before you know it, you've used up damn near all of that $20,000 or plus of deferral fees, and looking back on it, that bill's going to come due eventually, and you might feel like you didn't really get the full value. Whereas if you have a relationship with a service provider that's more pay-as-you-go, you're going to be noticing those bills, and you're going to be managing that relationship a little bit more aggressively, I predict.
Yeah, that's actually different advice from what I've heard from others, but I certainly took that approach when I had a startup, and it definitely kept me aware. I was determined to pay off part of it every month.
Yeah. So are you saying that you've heard advice that take the deferral fee arrangement if it's offered?
Well, sure.
Yeah, and that's a conventional wisdom, and I know that I'm kind of bucking the trend a little bit, but I just have seen time after time, and the larger the firm it seems to be, the greater the risk. I've had entrepreneurs come to me saying, I got $40,000 to this law firm, and they're not trying to collect it or anything because they haven't gotten funded yet, but I don't even have my stock certificates. And because of my experience, I've become skeptical that that's the right way to construct a good long-term relationship. Although it's pretty tempting. That offer dangled in front of you.
Yeah, it definitely is.
Yeah.
Okay, so I'm going to stop on one pet peeve here. We're actually running a little bit long here, but it's an important one. So I've had a number of clients who tell me that, I don't really need to get a high quality lawyer because a friend of mine, his mother's sister is actually is a real estate attorney or a tax attorney. My nephew's a tax attorney, so he's just giving me advice till I can afford to get somebody real. Any opinions on that?
If you need to do that, then you need to do that and try to make the best of it. It's not a good idea any more than I need a good developer, but all I've got is my newspaper delivery guy who's done his own website or something like that. And so he doesn't have any back end expertise, but I'm gonna use him because that's who's available.
Right.
I don't think you would do that for a mission critical function. And so obviously I would say, and not without a bit of professional umbrage mixed in, that you shouldn't do that. But look, if that's the resource that's available, part of bootstrapping is making it work with what you have available. So I'm not going to say not to do it either.
Well,
I hope you don't have to make that choice because I think it's a bad choice. But people do that. I do think it's a mistake. I do think the odds of making a mistake in terms of forgetting something, causing a tax issue, is very easy to do when you're distributing stock and having people work for you and not getting paid because you don't have any money. It's very, very easy to cause problems and not do things right. So it is fraught with risk. So I'm not saying don't seek a wide range of advice, and but I think the odds of making an expensive mistake are pretty great. It's a funny world, the startup world of legal issues and challenges. There's a lot of commodity type work involved, but that commodity type work is based on a foundation of highly specialized and sophisticated knowledge. So it's sort of a funny position to be in as a founder of a technology startup. You can negotiate for pretty reasonable prices on things like putting your company together and founder agreements, because as I said, one set of founder agreements and one certificate of incorporation looks pretty much like the next one. And so you can negotiate very good deals on that. But that doesn't mean you can go to somebody that doesn't know how to do it. So
Right.
it's commodity work, but in the hands of very experienced practitioners.
I guess if you need to take advantage of a friend or a relative who can give you some legal advice, is to make sure that you ask them every time, okay, is this getting to be out of your depth, or is this something that's not in your bailiwick?
Yep.
Yep. Okay, so moving along, let's talk about other more practical ways to limit expense, such as should the entrepreneur spend a lot of time on educating himself in legal matters, patent stuff, corporate documents, all of that. How can he help reduce his fees by being a more knowledgeable consumer?
You know, this is more of a personality test than anything else. What are you going to do with all this knowledge that you're gaining about the legal process? If you're going to use it to become a better consumer of legal services, great. If you're going to use it to sort of try to become your own lawyer, you know, maybe you're going to start causing more expense and problems than you need to solve. But I would think, yeah, like anything else, it's the legal function is a critical, to me, again, you know, blowing my own horn a little bit perhaps, it's a critical element of the successful formation, growth, and eventual liquidity of your venture, of your project. And so knowing why it's, you know, who's this guy with the suit and why is he always here? You know, knowing, you know, having a good, well-grounded appreciation of how the legal process is going to help you advance your venture is a good idea. So I'd spend a decent amount of time getting educated on it. I would read some good startup law blogs. I would get acquainted with the different types of dilutive and non-dilutive capital and have a good working knowledge of that. And then I would make sure that you have a relationship with your lawyer where you can call him or her up and, you know, not get a bill for you know 2/10 of an hour, and to ask, you know, what about this article I just read about this new funding mechanism? Is that going to be a solution for us, or should we keep looking? So, you know, part of educating yourself is having the ability to reach out for some non-billable discussions with your service provider.
Excellent, excellent. I'm going to pause for just a second and say, everybody who's online, if you've got questions in this general direction, or if you have a completely different matter that you'd like me to ask Jerry, by all means, please do use that question box. Otherwise, I've got enough questions. I could talk to Jerry all afternoon. So.
And I like questions because at least it proves to me that people are awake and I haven't put everybody to sleep. So you'll be doing me a favor if you ask some questions.
I will tell you that in the previous two webinars that I've done, they have been pretty shy for the most part. So it's not that they're not paying attention. No, they're still, the entire audience is still sticking with us. Okay, let's see. So. Let's see. All right, so let's move on to more practical matters. Well, what's more practical than money, but more specific situations, I guess. So for somebody who has technology that is patentable, when does it make sense to do a patent? When does it make sense to keep it a trade secret?
Well, I don't know what the general status of everybody's, you know, patent IQ is on the call, so I'll make a very general statement at first, and that is, you know, a patent differs from a trade secret in the following way. With a patent, you teach the world how to do your invention. You write it down in your patent application and say, these are the things I'm claiming to have invented, and here's the preferred embodiment. Here's the best way to practice my invention. Here's the best way to build what I have invented. And you publish it. And in return, that government to whom you publish it gives you a temporary monopoly on making it, after which anybody can make it, and during which sneaky people can copy it. And then you have to go find them and chase them down. A trade secret is something that you keep secret, and the longer you can keep it secret, the more valuable, you know, the longer it stays valuable to you. If I were to ask anybody for the best example of a good long-term trade secret, everybody's hand would go up, and everybody would say, oh, the recipe for Coca-Cola, and everybody would be right. And then if I said, okay, name 2 or 3 more, nobody's hand would go up, which to me demonstrates a couple things. Number one, a good trade secret is a very valuable piece of property, and number two, pretty hard to keep for a really long time. So really, in the window we're talking about, technology development, you have to ask yourself, what's the commercial window for what I'm doing. If I've got, Twitter, or if I've got an app that's going to be acquired by somebody eventually. I think which was the Greek startup I was reading about? Workable. I think were they acquired or were they invested in? I forget. That technology. Do we want to patent that? Do we want to claim that we've invented a new method tied to a machine that we can patent and show everybody how to do it? Or do we want to keep it either as a trade secret or just copyright the algorithm? I think that if you're in a relatively small market like Greece, and you want to address the European, the North American, and potentially the Asian markets, if you're going to patent your technology, you're going to have some very expensive decisions to make. If you were a U.S. company and you wanted to just start with the U.S. and maybe a PCT patent, I think it's a little bit of an easier decision to make because you have a very large market available to you in the U.S. With one patent application, and you can just go knock on the door of any patent attorney and get it done. My gut tells me that it's a little bit of an easier analysis for a U.S. company, and I'm still not that crazy about patenting software for a U.S. company. The other element of IP protection that we should throw into the mix here, at the risk of hopelessly confusing everybody, is the fact that, again, I'm going to speak of U.S. law here. Once you fix an expression, like a line of code, like a set of algorithms, once you fix that expression in a tangible medium, like again, your source code, you own the copyright as a matter of U.S. law, and you can register that copyright. And European legal structures are similar. So the ownership of the copyright in your code and the ownership of the look and feel and the user interface of your website, if you have a web-based product, is also an element of your intellectual property protection. That can be protected. So when I talk to founders about what they have that's patentable and how else they might protect their software, the questions tend to be, who else is going to come and try to do this? Will it be easy to figure out if they're copying your patent or not? What type of invention is embodied in the software? For example, I've got a financial services company, and they have developed a new way for traders of stocks and bonds on Wall Street to comply with the new SEC rule without losing too many hundredths of a nanosecond in terms of processing the trade. And this is a part hardware, part software solution, and it's a novel way of routing the information. And after thinking about this and thinking about how discernible an invention it was and who might try to copy it and where we might try to deploy it, the decision was made to patent it. Another software client I have makes supply chain optimization software. And after thinking about how they're going to protect, how they're going to deliver their product, they're going to offer it as a SaaS, a service, software as a service. And so people are not really going to see the source code. And they're thinking about the novel aspects of what they're bringing to the market and how easy or hard it will be to find infringers. The decision there was made not to patent it and to keep the copyright software as close to the company as we can. So it really depends on what you think you've invented, who might steal it, how best to protect it, who's likely to find out about exactly what you're doing if you don't publish it in the patent application, and where you're going to sell it. So we could go on and we could have a whole 3-month course on this, but I think that's enough for now.
Definitely, because we also have a few questions that have come in from the audience. First,
Okay.
just a comment. BugSense was the company that was purchased.
BugSense, yes. Mm-hmm.
Okay, so from Konstantinos, we have a question. Suppose that you are a small company with very limited resources. You try to save your funds for development and marketing as much as possible. Cost is crucial, and you need to keep it under control. Should someone reach an attorney before securing any funding? If yes, what are the costs in the U.S.? Can you provide
Absolutely.
me... Wait.
So,
This is a long question. Can you provide some sort of general guidance, like a list of things that are needed to be done, like company formation and the related costs?
Yeah, you have to have an attorney before you do funding, or else you're almost sure to negotiate, especially if you're negotiating with sophisticated angel investors or a venture capitalist, you got to have an attorney. A VC will not even invest in you really if you don't have a good corporate attorney and haven't been able to produce all the documentation that they're going to want to see. It's an absolute essential. So then it's the classic case of it's a chicken and egg problem, as we say. You need sophisticated, experienced corporate counsel, and you don't have any money because you didn't get funded yet. And so there's as I said, as I alluded to before, there's a number of different approaches that corporate attorneys take in terms of working with startups. One is the fee deferral. It's sort of a one-size-fits-all. We're going to do the work and we're going to send you the bills, but we're not going to expect payment until you get funded. I'm kind of down on that model. It sounds great, but it's like any free lunch. I don't think it really bears out. Another one is kind of a screwy model that's come up in the Boston area, where one of the large law firms here just put a bunch of startup documents on its website for free and said, okay, this is the founder's work, the founder's workbench. You can just come and take these documents and use them and goof around with them to your heart's content, and it's all free, which I think is just an outstandingly dumb idea because that's why you need a lawyer in the first place. My own approach to this, and this is just my own approach, I'm not trying to sell this, is, as I also alluded to before, some stuff in forming a corporation is commodity work. The next Delaware corporation I form is going to look a whole lot like the last 500 Delaware corporations I formed. It doesn't take a long time. You don't have to reinvent the wheel. It shouldn't cost a lot of money. So what I do is put a very small price on that, a flat fee, and they say, here's the bucket of stuff you get when you incorporate. You get your charter, you get your bylaws, you get your initial act of the directors, etc. The next bucket of things is if you have more than one founder, you need to figure out who owns how much equity. It all adds up to 100% all the time. So you need to figure out how many people are on this team, who's inventing, who's invented or is in the process of inventing the technology that's going to power the venture. Where are we going to take this? And who's going to be along for the ride? Once you identify those people, then you have to figure out, well, should we have an even split of the equity, or should one person get more? You have to figure out vesting. How long should people have to stick around until their shares are fully vested? Then you have to write all that up. And that's another piece of, that's a somewhat more fact-dependent piece of legal drafting. But again, very commoditized work. And if you do it right, your founders' agreement should look an awful lot like everybody else's founders' agreements. There's no need to reinvent the wheel there. So you can put together a pretty sturdy startup corporation for very little money. And then comes the fun part of, gingerly nursing that company along until you get some friends and family financing or until you get some seed financing and it can afford to pay for legal services. And that's a little bit of, pushing on one and pulling on another and just trying to make it work and not getting too far in the hole on your legal bills. And, that's when you need to know what calls are going to be billable and what calls are not going to be billable. And you need to, if you've got a non-disclosure agreement you need negotiated, figure out a price for that up front if you can, and do those types of things with your attorney to make sure you're getting value out of each interaction and that you're not going to be surprised by a bill. So biggest issue for startups and biggest issue for startup lawyers, and there you have it. And that's my approach is, my approach is sort of the relationship approach, I would say. It's got to work for both sides.
Absolutely. But, this is sort of, in terms of pricing in the United States, they don't have a lot of ceiling for that. So would you mind giving us some kind of an idea of the range and what, I don't know if people know what a Delaware, Constantino's follow-up question, I'm sorry, is we don't have an idea if it is like $1,000 US or $100,000 US. So if you can kind of tighten the range from that.
Sure. Now, let me just preface it by saying, you don't necessarily have to form a Delaware corporation. I think, if I'm not terribly mistaken, I think BugSense is a Delaware corporation. I think they founded it as a Delaware corporation. And I do think that's a pretty good idea if you're going to face the U.S. for potential funding or if you're going to face the U.S. for potential acquisition. I think it's a pretty good idea to form a Delaware corporation. You can do it from Athens, basically. You don't have to be a U.S. citizen. You don't have to be a resident here to form a Delaware corporation. You got to pay Delaware. Why Delaware? Delaware, appointed itself about 50 or 60 or so years ago as the state that was going to be the leader in corporate law, and I'll be darned if they haven't done so. The Delaware corporate statute is very well understood. It's perceived to be corporation and director friendly. They have an excellent court in Delaware that's established and that exists only to resolve disputes that arise under the Delaware corporate statute. So it's considered to be a very high-functioning, effective, and reliable state to have your corporation resident in. And if you're going to do any sort of venture capital from U.S. and from some European venture capitalists, it's a preferred type of entity to have. But you don't have to. You can have a Greek entity, you can have a UK entity, and at some point you can maintain a Greek entity and form a Delaware parent corporation to do the funding, and keep a Greek entity for whatever development team you have in Greece. That's another fairly common corporate structure. Now, cost $1,000. That actually happens to be the price I quote people for the first piece of corporate formation. $1,000 flat fee plus whatever you have to pay to Delaware, which is usually a few $100. And then the founders agreements, I have a flat fee that I charge for that. It's more than that's usually $1,500 or $2,000. But when you start getting more than that, you're getting misquoted. It simply, again, does not cost a lot of money to put together a Delaware corporation. When you start talking about trademarks, and if you find you have your heart set on one particular trademark, and there are 3 other ones kind of like it in different fields, and you need to sit down and analyze things, or if you have to start to have negotiations with people where one of your founders is being difficult and they want a bunch of non-traditional terms, and it takes a long time to negotiate the contract, yes, that starts to get into expense. Then you're sort of talking about how many hours did it take your lawyer to do the work, and how much is that going to cost. Legal fees in the U.S. tend to be pretty expensive. If you have one of the larger firms in Boston or New York or Silicon Valley, partners' fees tend to be between $700 and $1,000 an hour. Associates are between $350 and $500 an hour. Smaller firms, you'll be paying anywhere between $350 an hour to $500 an hour for your lawyer.
So a boutique firm that is also is well experienced in entrepreneurship is definitely going to be the better buy, as long as they have a good track record.
At the startup phase, yes, you don't need SCAD and ARPS to form your Delaware corporation. Unless if you don't have an international patent litigation going on, or if you're not going to do a billion-dollar acquisition, you don't really need the large firm. You do want a firm that knows the environment. You do need a firm that knows the early-stage funding environment, that knows the difference between a convertible note deal and an equity deal, that knows the difference between real seed money versus an experienced angel network financed deal versus a institutional venture capital deal. That's critical if you're going to be in the U.S. European early stage funding space. You need somebody that knows that. But the good news is there are lots of people that know a lot about that, and they don't all have offices at large firms.
Right. So a firm that isn't big enough to be multinational itself will often have agreements with local firms around the world. Is that right? Yep.
Every firm I've been in, large firms and small firms, and every firm I've been in has either some sort of lex mundi or law exchange or some other relationship with firms in other countries, or informal sets of relationships where I've got a client in Turkey, so I've met a couple of different Istanbul law firms that are contacts for me now. If I have a question that comes up in Turkey, I pick up the phone and call one of those guys. So and same thing in Greece. So yeah, you need somebody that understands the international aspects of what you're doing as well. If you're in one jurisdiction, then you're going to address or form your company in another jurisdiction.
Great. So let's see. So we are down to only another 10 minutes or so. We have one other question. Yeah, time flies when you're having fun. So is there value to filing a provisional application?
Yes.
Can you expand on that?
Yes. if you file a provisional application, you get the filing date. It's first to file under the American Invents Act. Now we join the rest of the world, so it's first to file. So if you've invented something, it's good to file an application. You get a year to sort of figure out what exactly it is you're claiming, because you don't have to reduce your provisional application to a utility application for a year. And you can raise money on a provisional patent application.
Yeah.
It doesn't make any difference at all. Sometimes I wonder why, but it doesn't seem to make any difference at all to an investor whether you have a provisional application or a utility application. For the most part, if you've got a really savvy investor that really knows the space, knows who's competing with you, and understands the freedom to operate issues, they might push back. They might push back on you. But if you have a provisional application that's been filed by a decent patent attorney, that's a good foot in the door in terms of establishing your bona fides to a potential investor. So it protects the disclosure. You can once you have a provisional patent application filed as well, you can talk about your invention without worrying about making a so-called enabling disclosure, which will cut off your patentability in some jurisdictions and limit your patentability in others. So I think it's a great idea.
I was actually running an event yesterday for the UMass Medical School, and one of the ways the Bill Sellers from Novartis put it was that that essentially it's like getting an extra year on your patent.
Yeah, and that's the way the life science guys do think about it. And because,
well, they have to.
Well, yeah, because you've got this. If you are doing a pill or a therapeutic or something like that, I mean, every extra month you can squeeze out on your patent is just enormous, because that's the better your drug does, and the longer you can keep that monopoly, that's those incremental returns are great. So and he's exactly right. You lop another year onto the patent. Now for software, not as important. Your software is going to be done and gone and over and replaced by the next generation stuff long before the 20 years goes by. Probably. I mean, probably. So, but for the drug guys, absolutely. Every day they can keep their patent monopoly is a big deal. So that's exactly how they think of it. But even for software guys, like I know we have a bunch of software folks on the phone today, it's still a really good idea because you don't want to be out there, pitching to somebody or at a business plan competition or publishing and make an inadvertent enabling disclosure on your technology and lose patentability. So if you can cobble together that provisional application and get it on file, you've done a good thing. And then you can go to a PCT from the provisional as well.
Could you actually explain both of those terms, provisional and PCT?
Oh boy, I better not, because I confess to not being a patent attorney, so I don't want to give up patent advice. But the patent cooperation, I'll suffice to say, the Patent Cooperation Treaty is a treaty to which many countries in the world are party, and you file one PCT application, and it buys you time in a number of jurisdictions to figure out what countries you want to go into. But further than that, I shouldn't jump in and let you talk to your patent attorney about the nuts and bolts of how to do that.
Oh, absolutely. It was really more kind of a definition that we didn't really explain what a provisional actually was. I just asked
you called me on some jargon, which you should, and that's a good takeaway from this call. If your lawyer says something that you don't understand, don't say, hold on, what exactly is a PCT, or what the hell did you just say? Because you're paying for that explanation. So good call. When your professional service provider starts lapsing into jargon, give them a good slap upside the head.
Oh, and you know how much I enjoy that. Okay. So in these last few minutes, let's switch gears a little bit and get your kind of input on a more strategic kind of issue. What do you find the costliest mistakes are that entrepreneurs make most typically?
Oh man, we could have 5 hours for this one. Okay, here's one: being too casual about distributing equity to your founders. Having a guy out there in the woodworks and you're saying, well, yeah, he has 10%. Well, 10% of what? 10% of what? Of what measured when? Subject to what kind of dilution? Talking about stock in terms of percentages is very dangerous. Another big mistake is to not nail things down at the very beginning. if you've got a team of founders, get them to assign any intellectual property they have, anything they've invented, anything they've contributed to the venture, to the company. Form the company, get all the founders to assign their rights to the company, and give them stock. Now you have a company owned by the founders. Their stock is subject to vesting and restrictions and buybacks and stuff like that. And the company, not any individual, now owns all the intellectual property and owns that corporate opportunity. That's the way it should be. And one of the biggest mistakes I see with startups is that they wait to do that, and they assume that everybody's getting along today, so everybody will be getting along tomorrow or next year, and that never works out that way. It never gets easier, and it never gets cheaper. So get your corporation formed, or your LLC, or whatever entity you're going to form. Get it formed, get that opportunity, and get that associated intellectual property within the entity, and give people the stock now in exchange for those contributions, and move on from there. That can be the biggest one. Biggest problem today.
The most egregious case I have for that, you're going to have to come to the Perfect Pitch workshop for me to tell you that story, but it's a very sad story. You should all know.
I bet they don't.
Oh, you know it. But moving right along, we have another question from the audience. What are the tricky parts in getting funding through a convertible equity?
Convertible note, you mean?
I think that's what he means, yeah.
Yeah. Well, actually, it's funny you should mention that, because convertible notes, and this is going to be if you're touching the U.S. at all, convertible notes are great, because equity financing requires you to say, okay, my company's worth $5 million, or my company's worth $4 million today. I'm going to sell you $1 million worth of stock. The math goes like this: you just gave me $1 million, so you own $1 million worth of whatever this is. Whatever this is now worth $5 million. It was worth $4 million before, plus your $1 million. So you, investor, have 20%. You have 1/5 of the company. Problem is, when you're a startup, no investor is going to say, okay, you're worth $4 million or you're worth $10 million. You're not worth anything. But you need that money to go achieve a milestone so you can convince that Series A investor that you are worth something. So you take the money in as a loan, you apply some interest to it, and you say, you can convert this into the Series A at a discount when I sell the Series A stock. You know, every dollar's worth of stock I sell to the Series A investor, I'll sell to you for 75 cents. That's your discount. So that's great. But there are problems with convertible notes. Number one, under U.S. tax law, you have to recognize interest income if you're an investor in a convertible note deal. This comes as a surprise to note holders. Quite often, many companies out there and many law firms out there do not require companies to provide 1099s for their investors. But that's the law. So people run into that problem a lot, and people run into the problem when they're converting the notes into a Series A deal, and they find out that the company has not been recognizing that interest income and providing the tax documents to the note holders. Another issue that happens, especially with respect to cross-border convertible note transactions, if you're a U.S. issuer, let's say you form a Delaware corporation, and some of your note holders are in Greece and Europe. Again, under the U.S. law, to which you're subject as a Delaware corporation, you have to withhold an amount payable on that for tax on that interest income, unless the investors give you a tax form called a W-8 BEN. Now, that's never mind what I just call it. It's a tax form that investors have to give you, and some European investors are not equipped to do so, and some European investors are pass-through entities with a bunch of limited partners, and they don't want to give you that information. And it can be a real problem. So convertible notes are not the panacea that people sometimes treat them as, or that people used to think they are. So I've actually become a proponent of a series of preferred stock that I use and that I try to get people to consider in these circumstances that acts like convertible note in terms of a stated dividend that acts as interest. It converts at a discount into the Series A like a convertible note does, but is not debt. It's equity. So you don't have interest, you don't have tax reporting, you have a capital instrument in the hands of your investors, and it converts into the Series A equity. So I be wary of convertible notes is the takeaway, particularly if you have a U.S. entity issuing notes to non-U.S. investors. It can be very problematic.
Great, and that really is the conventional wisdom, that's the right way to go, so I'm glad you said that because it is tricky.
I can't tell you how many deals I've had with convertible notes where unexpected problems come up, and there's such a lack of unanimity among otherwise, sophisticated and experienced practitioners as to how to deal with these issues. So when I see a situation like that, I think of, let me come up with something that's much simpler. And so I think convertible, the type of convertible preferred stock that I just described is the answer.
Great, thank you, Jerry. I will give you guys a few more seconds to put in any last questions. It is 1 o'clock now, and I am expecting a meeting in the not too distant future. So as long as the person is late getting here, we can keep going. I'm going to just go through the follow-up on what's coming up, and if you have questions, I'll keep looking for them. And otherwise, I think we're going to have to say goodbye to Jerry. I hope you guys have gotten as much out of this as I have, and understand why I respect Jerry's capability so much. Okay, so write those questions, and let me just touch on, let's skip that.
And by the way, Linda, anybody who has a question that comes to them afterwards, if they have my email address, they can simply send me an email and say, I was on that webinar, and I have the following question. I'd be happy to get back to you in terms of anything I said that confused you, or if you want some more information about any of this.
And that is GO'Connor@Saul.com on your screens right now. And also, I'll try to get this uploaded to YouTube before I get on the airplane tomorrow, in which case you can just look it up there. Okay, let's see. We have a thank you. Thank you. We always appreciate knowing you got something useful out of this. Let's see. Right, so tomorrow at 14 o'clock your time, 10 o'clock my time, we'll do a final webinar where I'll tell you about the things that will get you the most value out of doing the workshop to prepare ahead of time. And also for those of you who want to try out your current 1-minute pitch, I'll give you some coaching online. Don't forget to sign up not only for the last webinar, but also for any of the Build the Community programs at the great website that Katerina has gotten put together. And finally, of course, and always, best of luck, best of success. It's really wonderful to have you participating in the webinar, and it looks like all we have is thank yous from the audience. So thank you from me as well, Jerry.
Okay,
and,
no, not a problem. Happy to do it.
Excellent. All right. Take care.
I enjoyed it. Okay.
Good, good.
So long, everybody.
Bye-bye.